Thank you so much for giving me the opportunity to share a very meaningful and a purposeful work that is regarding how to write a legal assignment, and which today has emerged a base for the law students also, because in every segment of the semester, it has become a necessity, since more and more students are now in for presentation of the papers at the conferences. But the real issue is that students are not guided how to proceed it. It is simply you write it, but that does not make any sense unless a child is a student, even if they are graduates or undergraduates, they need to understand that what is the methodology, what is the criteria through which they can put forward a good paper presentation. When we say a legal assignment, the first criteria is to identify what topic the person wants to work upon. Is he interested in writing an essay? Is he interested in writing on some case that is going on currently? Like Jessica Lal's murder case was in news over a long, long period of time. Sushant Rajput's suicide. Number of news clippings were coming forward. But when it came forward, how to write an assignment on a topic which is a case study, where new things are coming every day. So the student or the person interested in writing an assignment need to first identify that what is the nature of the assignment. What is the problem? Am I going to understand and apply the law to the facts of the problem which is before me and proceed accordingly? Or I want to go in an essay-based methodology. So idea is that if we are writing an essay, then we'll directly discuss the legal issues one after the other in a chronological manner. And then we will analyze and assess those, and then we will critically conclude on that. But if we are going in for a case-based study, then it needs a wider purview. Why we have picked up that particular topic? What is the need? Then we also look into the fact as to what is the history, how that came forward. If take for example, if I give you a very small thing, meaning of the word law, functions of law, being a law student, then the first thing is to understand to how to introduce the term law. What is law to a layman? What are the principles which are involved in law? What are the various kinds and rules of law which are necessary? Whether law implies a body of rules and regulations, or we can say law is justice, or law is morality, law is reason, it is logic, order. So what intention is behind the coining of the terminology law as a body of rules and regulations? Now, there are innumerable laws which have been born, whether it is the statutory law, or we are looking at the ordinances, or we are looking at the judgments which are delivered by the courts of law from time to time. It is a decree of the court of law. So what is it? Everywhere we are using this terminology, law. Law, environment law, law of torts, contract law, criminal law. So everywhere the word law is being, today we are using cyber laws. So once digital laws. So how do you start with the general introduction as to law as a body of rules and regulation? You can give the various meanings that can law has. Then we come down to the technical meaning of the term law as to from where did this word originate. Take, for example, if we say from an English word, the earlier the word used to be lagu, then it became law. Similarly, various countries have used this word. In India, we were using the word dharma, which meant the rule of law. The French have been using the word just. Germans have been using the word droit. So each terminology has been referring to the single word, that is law, a body of rules and regulation. So once we write an assignment, the first thing, if I am take, for example, the meaning of the word, an introduction, you can give an overview, a brief of what we try to understand by the term law. Then what is the traditional meaning, or that meanings were assigned to the term law by different countries. So that is how we start with the first thing of identification of the terminology and the what we intend to cover within it. Then what would be the scope or purview of this terminology? What I want to assess law, its various aspects, its various kinds, and how law has been time and again being used, and how we have been modifying the law, interpreting the law in such a manner that it is justifiably addressing the grievances with which the aggrieved are approaching us for seeking justice. Then we make an attempt to define the term law. Since it is very wide, you can take any term, not necessarily law, but whatever is your assignment, then you define the term which you are using in that particular assignment, so that it is clear that what are the legal definitions. In the legal definition, whether there are traditional definitions, you can address those. Which jurists have tried to address, or sociologists have tried to address that, you can define those terms. Then whether that term has been criticized by the other jurists or the sociologists or legal experts, then you can also add that this is the definition, but it has not been accepted, and these jurists or sociologists or experts had an objection to it, and they intend to interpret it in this manner. Now, if I take the example of law only, we say law is a command of the sovereign, as Austin's identifies and defines it. But there are other jurists who never were in consensus with this terminology that law is a command of the sovereign. They perceived that he has the oversimplified the definition of law when he says it is a command of the sovereign. Every command cannot be a command of the sovereign. Who is to be treated as a sovereign? In a country like India, who is the sovereign? For us, the constitution is the sovereign. We do not have the king. The president is a replica of the model of the king, the crown. But being a parliamentary form of democracy, we are governed by the constitution. The president also comes under the domain of the constitution. So he gets its powers, privileges, functions as specified under the framework of the constitution. So once we have identified, we are in a position to analyze which topic I am to discuss, what are the major identifications that I intend to go through. I know this is my scope. I want to analyze what are the powers and functions. Why is a president called a titular head? Why he is not empowered? Is the governor authorized to act on his own? Or again, he has to toe the line of the government? The number of times there have been governors who refuse to go down to the policies of the government. So is that within the purview of the framework of the constitution? You can assess and analyze the scope of the powers so that you are able to justify that how I will proceed further. So once we have cleared the legal definition, the traditional definition, the modern definition, then we can come down to the currently what is defined as the rule of law, how it is being addressed, or and how that is being implemented and enforced in the society at large. Now, once we have achieved or defined the term, then we try to understand what is the importance, how far it is important, how far the subject is necessary to further understand that whether the rule of law should be prevailing, or there is to be a rule by law, or the law is self-capacitated to bring about the transformations that are taking place in the society. Now, under the main body when we are then address, once we have reached up, understood that what is the relevance, what is the importance, what is the scope of the subject, then we come down to what developments or in a chronological order or historically evaluating it, we can specify from where it originated and how it has grown over a period of time. That depends upon, again, upon your discretion. You want to go restrict it to a particular segment, or you want to go on a broader perspective, or you want to make a comparative study of India with any other country, say UK or USA or Switzerland or China or Japan. That is purely your prerogative as to how you want to address the assignment, or what is the subject that has been given to you, and within that scope, how much you are capacitated to do the thing. Uh, it can be related to anything. Take, for example, it can be a matter of marriage or divorce. Same, you can have the same methodology. Only thing is you identify the issue you want to take up, and accordingly you search for the literature. You first need to do your homework very well as to when it started, when it originated, how it originated, what circumstances went in to bring it into that format. At times, there are a number of reports which are available, which gives us an information that of the historical or the development that led to the bringing of that particular law into existence. Take, for example, your Dowry Prohibition Act 1961. That is perhaps one legislation which was implemented with a two-third majority, but that is the legislation which is not digestible by the population at large. You will hardly see any marriage being performed where dowry is not a part of it. But our law says it is a gift. It is a dowry if there is a giver, if there is a taker. But most of the people, when it is at the time of the marriage, it is the gift which is exchanged at the time of marriage. So we can, when you are writing a legal assignment, you can analyze and assess, and the purview of the objective with which this legislation was brought into existence way back in 1961. But whether the population consented to it, was it a legislation which had the popular opinion, the public opinion, or it is because the government wanted? Since the government was in majority, so it brought the law into existence. How far this law has been enforced, how far it has been effectively enforced, have we been in a position to prevent dowry deaths? 1961 till today, we are standing in 2025, but there has been no end to incidents of dowry death. So assignment, you can also include not only the legislation, but also that the dowry death was also included. We were not having it earlier, but it was included in order to ensure that there is a check. Women are not being eliminated in the name of dowry. So you can add these within your assignment, justifying that how the sequence of events had happened, as a result of which the legislation came into existence. The legislation was enforced, it was implemented, but its application was modified by the population to suit their circumstances. So long the things are very good, it is a gift. Once it runs into, your marriage runs into rough weather, it becomes a dowry. Then comes 498A, then comes 304B. And then we have, no doubt now, we have the new BNS and the related provisions that have been added to it since BNS has been implemented by the government of India. So looking from that perspective, you can even add that aspect into your assignment, that this was traditionally the code and this is now the new provisions which have been added in the code, in order to provide more weightage to your assignment and a better authenticity and current knowledge It was not that you have picked up someone's work and simply copied and pasted it, but that you are aware of what are the current events or sequence of the event. You can even add a comparative table to it to clarify that this is what is the current situation, and these are the new provisions of the law. In addition to it, when you are tracing the growth, your development as per the demand of the topic which you have chosen, if there is some landmark cases, then you can add either as a judicial purview that judiciary has been taking up the matters and it has delivered judgments. For example, dowry deaths. There are innumerable judgments which have come from the court of law. And in every case, the decision is varying because it is dependent on the facts and the circumstances of the case. So you can take up a small crux of the facts and what was held by the court of law. So everywhere, for every case of dowry death, punishment is not coming forward. If the onus is on the husband to prove woman died within 7 years of marriage, if he proves that she was suffering from a mental problem, she was psychologically not fit, she was under medication of depression or anxiety, then he may escape being penalized under dowry debt. So circumstances will vary, whether there was an amendment to it. So circumstances, situations will vary. So every case is modeled on a different line. You can pick up cases which align with your legal assignments topic, and accordingly, you can use them chronologically. You can take the case from, say, 1965, come down to 80, 85, then up to the current position of how there has been a change. Then the Supreme Court has been delivering, it has been interpreting the law to ensure that we brought in a new phase of law, that rather than going in for litigation, we brought in mediation as a methodology to save the breaking up of the matrimonial homes. So there has been the introduction of this process. So you can add that in the your body of the assignment, that in order to ensure that the marriage is restored back. There are differences. Differences can be overcome if there is a proper mediation or a via channel through which the parties can be asked to interact, to communicate, to discuss, to clarify their problem, so that if there is a possibility, the marriage can still continue rather than to go for a divorce. Then if they are, you can also make a small reference depending upon the requirement as to mediation's primary objective was one, restoration and continuation of the matrimonial alliance, and secondly, the interest of the future of the children, because they are the worst victims once a marriage is going into rough weather. So they should not be put into that kind of a legal hassle. So you can pick up few good quotes which have been delivered by the courts while delivering their judgment, or even passed as an obiter dicta, in to give more authenticity to your legal assignment. And it also ensures, once you read the assignment, that the student has done the homework. He has gone through all the things, the vices, the positives, the negatives, before sitting down to write the thing. Then use chalk out the core issues and then address those issues, that in my assignment, this is the major issue I am looking forward to, and this is how it need to be addressed. Now take, for example, every marriage which is running into rough weather, dowry is not the issue. It can be because the expectation is to have a male child, and there is no male child. There are 2 daughters, 3 daughters. So that could be a very strong reason which has given the shape of a dowry death, because that is looked upon as the easiest way to get rid of the woman. Then to go for a divorce rather than for elimination of the woman. So what is the mindset of the population which opts for elimination rather than for divorce? then why divorce is not preferred in contrast to death? Then legal separation, judicial separation is also a provision under the law. Why it is not opted for? Why always people say, eliminate the person. So you can look at the pros and cons. Every time we have this kind of an issue, a divorce case takes years and years in the court of law. Whereas if the woman is eliminated, how much time it will take? You can go and marry. Or if even the male is eliminated. I will not say that it is only one side today. Today, the crime is being committed on both sides. Even women are indulging into such kind of practices. Uh, all of you would have seen the news of Raja Raghuvanshi, who was eliminated just shortly after his marriage by his wife. So things are happening in the society. So we will not say it was a case of dowry death. Was it a case of an extramarital affair? Or she was not interested in the marriage but forced into that marriage, but she married by her own choice. So alternatives are available. So when we are writing an assignment, our perspective is to purview what is the topic and to what extent we can give the inputs to it. So we have so many alternatives which are available, and how you can specify them, that these are the possibilities under which the divorce could be restricted, or through mediation, the parties can be channelized to adopt a more methodological way, and so that their marriage is restored and the future of the children is also taken care of, rather than ending a marriage in such a wrong methodology. Or they can part, but they can still continue to be good friends in the interest of the children. So idea is to identify which aspect the student wants to work upon. Then all statutory laws, all rules, all legal principles can be evaluated through reference to the cases. So it is your choice. You want to discuss the cases and then you do it, or you do parallelly side by side. So that depends upon how well you have first done your homework, read the law clearly, so that you can correlate the two things and go on side by side. You can even make a table. That is your choice of how you want to make a presentation and how effectively you can make a presentation. You can even represent the things grammatically. So that is again your prerogative or the writer's prerogative as to how he would like to address those things. Then whether the facts, the problems that you have looked upon, you have identified, or on which you intend to justify, then you should have a very clear approach and understanding. It should not appear that being the writer of the assignment, I am myself not clear with the facts. I'm not clear with the law. I leave the things hayway. I am not able to specify which provision is addressing. So that does not give a good presentation, and it is not more appropriate to add those things about which I have a constraint of knowledge. So you should be very clear and specific. Then is to analyze what you have written. Critically assess the facts, the law that you have specified, and evaluate it so that the reader has an understanding that it is not a cut, copy, paste model, but the writer who has done the homework, has understood, and has provided a solution, a suggestion, a recommendation. Apart from that, it is very necessary that whenever you write an assignment, be very clear, very specific, very precise about what you are writing. It is not important that your sentence should run into 10 lines. One sentence is ending in 10 lines, 15 lines. It is not a symbol that you are very intelligent, but how clearly you can address it, how clearly the meaning is understood by the reader. I'm not writing for a very high intellectual class, or my methodology of writing also conveys how well I have understood it. So, in order to ensure that it is understood, it is communicative, and people can get an input out of it. So, the formation and the language, the selection of the words, the context in which the words are used, that must be done meticulously, clearly, and it should be in as simple a language as it can be understood by the larger part of the population. Then it is always better to use an academic language, avoid slangs, which has today become a very common fashion or a statement to use slangs in your writing. You speak slang, you write slang also. But that is not to be done when you are writing an assignment, a legal assignment, because that gives a very bad impression. It is not a language which is to be used in writing, in drafting, uh, or in the legal terminology. So should avoid using such kinds of acts. Then again, it is a very common fashion these days that we are living in a digitalized world, and chat GPT. It is very easy to give a command and the assignment is ready in a few seconds, and you perceive that my job is done and I have done it. No doubt, you take help from Google, you are taking help from Wikipedia. Now you are taking help from ChatGPT. But again, you have your own mind. You can analyze it, you can assess it, you can process it, and then you reproduce the things. You can read all the three. The content is available to you. Then you write it yourself so that your inputs are added to it. Your language is there by which you are able to address if someone is asking you. Coming from the chat GPT, you will not know a single line. It has given you the entire historical background. You have not read anything, you put it before the person. Any question you are unable to address. The language of the chat GPT is very easily identifiable. People like us who check so many things every day, who got to hear, who attend so many places, it's very easy to identify that this is not a student's work, but it is the work of the chat GPT. Number of students are today writing their dissertations through chat GPT. Even PhD theses are being written by through chat GPT. But the AI model is there. But it is that human being is far more intelligent than an AI, because we are making the AIs. That means you still have a better brain capacity. So your objective should be that if you are using all these digital resources, no issue. Today, people are not bothered to go to the library, sit over there and read the books. You have 10 excuses, it is laden with dust, it has termites, all those things. So net becomes very easy and accessible. But still, the knowledge that you get from the books, the contents which are there in the books written by the authors, there is so much which you, once you read, you get of it, which you will not find it on the net. No doubt, ebooks are also available. Read them rather than only working through AI and chat. So once you are doing, working upon that, your knowledge is available at your end. How to use that knowledge? See, you use these techniques because everyone is using it, so we can't say don't use them. But then use your intellect, use them intelligently. So do not become puppets in the hands of the AI, but use the AI so that it is a facilitator to your work as to what you want to get out of it. Then every assignment, it is very necessary that you should conclude it with your findings. What you wanted to do, what you hypothetically thought that this is what I am trying to conclude upon it. So that must be justified in the end, that I succeeded in arriving at this conclusion, or I could not come to the conclusion with which I started upon it, but I have a different perception. And then how you critically assess that, and then what are your suggestions or recommendations. If you feel, you can even give a draft proposal that had the law being made in this fashion, it would have been a better law. So you can draft a law which can be also be a part of the assignment, and it can subsequently be forwarded to the government as a draft proposal for bringing about a necessary amendment in the law, or for bringing about an altogether new law into existence. So governments are also inviting proposals. But again, it depends upon how much homework you have done or how much well aware you are. Then number of assignments, the work is plagiarized. Everything is a cut, copy, paste model. What is your contribution in it? A said this, B said, C said. Then what did you do? Nothing. You only picked up patches and you aligned them together, and the assignment is done. So that is a very, very wrong methodology which is being used, and majority of the people are using it. If you read most of the papers these days, they are nothing short of cut, copy, paste. But the fact is that it is not, you are not learning anything. You're not doing anything. You may be increasing or multiplying the number, but end of the day, what is the credibility of that paper? If we rank it, it stands nowhere. If you intend to gain something out of it, you will not. Tomorrow, if you read your own paper, you will regret this is what I had written at that point of time. So the effort is to emphasize on clarifying the things, change your approach, your perspective. You may not succeed the first time, but you try, you work out on your loopholes, and you can definitely write a better paper every time, or a better assignment once it is there, because clarity is going to come through writing. It is the basic key. So once you clarify the thing, the more you read, the better your concepts are clarified. See, if you read the Constitution of India, Article 21, I will say, every time you read that one line article, you get a new thought, a new ideology. Even the framers of the Constitution, when they wrote the Constitution, they enforced and implemented the Constitution, they might not have visualized that Article 21 can be given so many connotations. It can have so many meanings. Air is within, water is within. We even brought right to sleep within the fold of Article 21. So we are, everything to anything is today uh, brought in within the fold of Article 21 to the framework of the Constitution. So similarly, if, innumerable provisions are being interpreted, the onus is again on the interpreter as to what is your mindset and how you are trying to address it to ensure that right to life is to be protected, and these hindrances in the protection of right to life, enjoyment of right to life, need to be withdrawn or taken away, so that a person has a better freedom and he can ensure that he's actually living his life as required within the meaning of law. Then every assignment should have references. Whosoever you are taking help from, assistance from, the books you have quoted, the authors, articles from of whose author, then those persons need to be obliged. It should also have a good bibliography at the end, so that the reader knows that these are the books which have been referred to. These are the authors who have been writing on these things, so that they can also seek help, aid, and assistance, and they can also use it for their uh, whenever there is a need for them. Whenever writing their own paper, they can also take help from these things. So the again, when you are writing an assignment, rather than only changing the paragraphs, you can give separate headings. You can again give subheadings. You can make it into points. You can use bullet marks, so that whatever you are saying is easily identifiable, and the person reading it is not getting bored by reading paragraph. He is able to identify, this is the thing, then these are the kinds, these are the types, this is the meaning, these are the core issues that are involved, this is the importance which is there if we are using this particular rule or provision of law. These are the definitions which have been specified. So they complement and help in creating the interest of the reader in understanding and reading the uh, assignment. All legal provisions that have been used, it is your uh, aptitude that you can use both the primary sources as well as the secondary sources. You can use only the doctrinaire methodology in writing the paper, or if you have a keen interest, you can go for an empirical data also. You can prepare a Google map, the Google form, and then you can enlist what topic you are working on and who are the people who can provide you assistance, aid, who have knowledge, who are either dealing on that subject, who are related to that, who are addressing those causes, or who are victims of that situation, or the common population who can give some references and opinions of why these things are happening in the society every day. So that can be made, the data can be analyzed, it can be represented in a bar graph or a pie chart method, and then you can take out the analysis to give that these are the reasons for which these particular acts are committed. And this is where law is calling for a change. How judges have been addressing the cause from beginning till today, 1960s to 2025, we see a long transformation in the methodology of deliverance on the part of the judiciary. Concepts like transgenders, at time not even heard of or talked about. But we had a judgment of Tej Singh Johar versus the Union of India, where we are saying that they are also a part of the framework of the Constitution. So we, the people of India, is including the male, the female, as well as the third gender, which was not conceivable when we wrote the Constitution of India. We simply use the term we. Now, who is we? We normally said it is the male fraternity. Then we came to the term of gender equality. Then we said no, gender parity should be there. So then we came male, female are part of the framework of the Constitution. Then the transgenders now are also being added. So male, female, and the third gender is now also a part of the framework of the Constitution. So this is how we analyze and assess the growth, the reason. Once you read the case law, you get to know that what were the reasons behind the bringing of these transformation. What convinced the judge? What was the arguments that were given forward? Okay, we can say that the judge was very moderate. He was like a younger generation rather than the traditional model. He was not a patriarch, so he accepted these changes, but that will vary from situation to situation, circumstance to circumstances. Again, the judgment in the case of Sabrimala. No, so many people have written about the incident. So many people wrote about the judgment, whether it was good, whether it was bad. It should not have been done. It should have been done long time back. If something is ordained, then the judiciary should not try to hurt the sentiments of the population, but still the judgment came on the table. How far the judgment is practically implemented, that is another question. But when we are writing it, we take into consideration all the pros and all the cons. So the objective is once once there is a clear understanding of what I want to do, what is my core target as to what all things I would like to bring within my assignment, then identification of those things, and then we make a list of the issues which I will talk about, on which then I will conduct a thorough research before taking the pen and paper to write it down. So these are the essentials which must be there when we are writing an assignment. Then when I say interpretation, now see, interpretation is also an art. It is not that judiciary is the interpreting body of the Constitution, so it can interpret anything. Law is written down. We have the codified laws also. We have the constitution, which is laying down a very clear law as to what is done, what is ordained from being done. Along with that, the responsibility is there on the judiciary to read every word which is there in the statute. How to read it, whether the meaning that was is there in the word that is to be given, that is the literal meaning of the words, or we can go for the use of the dictionaries. We can give a grammatical meaning to it. That is the meaning understood by the population at large. So, which meaning is to be given? That is to be identified when you read the provision of the statute and assess that what was the mindset of the drafter when he had used that language and had written that meaning. So once you understand that there is a clarity, then there is a need for interpret. No, interpretation does not mean that I can say anything, I can speak anything, I can distort the language of the statute to my convenience. My objective is to understand what is the provision of the law and explain that provision in a very simple manner, which is understood by everyone that this is what the drafter intended to say. Since the statutes, they are all written in a legal language, it is not a common man's language. And normally you will witness there are so many punctuation marks. How to read those punctuation marks? So when you're writing an assignment, you need to read those, the commas, the pause which is there, the hyphen which is there, the semicolon which is there, the provisos which are written over there, so that you understand as to which word is to be given importance, which word can be ignored, which word need to be given a more meaning, a better clarification, and whether the proviso should be read before the real provision or it should be read subsequently. Every statutory body has headings. So we read the headings as a method of understanding what is contained in it. So same purpose your assignment should serve. So when we are writing definition, that means I am carrying the definition. Meaning, traditional definition, modern definition. Similarly, then when I'm saying what is the importance and significance, then I should be only talking about what is the significance of the topic on which I am working on. I should not be working about here and there. Then if I am emphasizing on the primary sources, I should clearly insist that these are the primary sources and this is how I have used them. Secondary sources, if I am relying upon, then which secondary sources I have picked up and on which I will be working upon. So this brings about a better understanding and a clarity on which the author can work upon. Now, these days we have number of uh, models which have been evolved through which the plagiarism can be checked. We have the Scholar, we have Turnitin, we have Delivered. So depending upon which institution is using these, we put these your paper on these so as to assess whether it is the plagiarized material. It is even capable of checking the AI content. So whether how much part of the AI content has been used. So it gives you an entire, your article is put over it and it gives you an highlighted version. You have picked up this percent from this article, from this book, from Google, from Wikipedia, whichever you are using, it is bringing that. Now that gives another issue which the students have a major problem, that if we are taking from the book, if we are quoting some author, even though we have obliged him, we are giving a reference of him in the footmarks or at the end notes, still it is showing as plagiarism. Now, for that, we use various methodologies. No doubt there is a problem that it goes by picking through the words. If you're using the word quote, law, if it is picking that word, it will highlight that word wherever and whenever you have used it. Now, when you write a legal assignment, you may be using these terminologies of repeatedly. So there, we can use a methodology where we can get the words enlisted that these are to be excluded when we are going for a plagiarism check. then it is always better when you write an assignment that you prepare a structured outline so that you are very clear and sure that these are the issues which I will be taking up. These are the rules on which I would apply when I am writing my assignment. And this is how I would develop a structured analysis, the body of my legal assignment. So you can divide it into equal, clear headings, subheadings, so that the reader is also comfortable and you are also clear on what you are focusing upon. Then whether you will go only on individual or you would like to do pick up more than one theme which is aligned or correlated to the main theme. So you can address those issues side by side. Like take for example, if you're talking about marriage, these days along with the marriage we are using um, living relationship, we are also using extramarital affairs. Then there is another term which we are using, that is the marriages where uh, people are entering into unlawful relationships which are not being authorized by the customs and traditions, and which has given birth to the practice of honor killings. No, marrying between the spindas, but at the same time, there are customs which permit such kind of marriages. So you're falling into the domain of the custom law, or you are on the other side indulging into wrongful acts. So it is the discretion again of the writer whether you will take a combination of these things since they are correlated, or you will take them independently since each has a sufficient literature and history, number of case laws, or where you can, even if you take them up independently, you are capacitated to address them. So again, it depends upon purely upon your choice on the right of the author as to how he would like to analyze them and prepare a body and then take them up one by one to arrive at a determined conclusion. Every assignment must be having the clear provisions of law, the definitions, the rule, analysis, and the conclusion and suggestion part. So it is mandatory that when you are writing an assessment, you cannot abruptly end it on a conclusion without laying down as to what lacunas you believe that despite the law being made, the judiciary being very active, still these are the flaws which are still there and which need to be reformed. And to bring about those reformations, you are laying down a few suggestions which, if implemented, will definitely provide a better environment or would check the commission of such kinds of crimes which are taking place in the society, or violations in law which are there, or any such kind of acts and conduct that can be restricted if these suggestions or recommendations are brought about within the fold of the society. So writing an assignment requires an effort where you try to understand that it is not just putting down few words on a piece of paper, but it is an effort to project your mindset, your thought, your knowledge, and how well you are capacitated to argument on those issues, address them, and bring down to a conclusion whereby you are also clear that this is what I thought of and this is what I have suggested. And if these suggestions are used, it will definitely bring about a reformation in the society. So that is a properly written, channelized legal assignment, and that will help and facilitate in understanding the subject from a better perspective. So that is all from my end.
Ma'am, can we take questions?
Hanji.
Ma'am, there is one query. What if we don't have Manupatra or SCC online subscription? How can we do an effective research without making use of these portals?
That does not at all make a difference. If you don't have Manupatra, you don't have SCC, no issues about it. You have your digital Google is available to you. You have a library, e-books are available to you. Elsevier is there, which is free. So you can use them. Manupatra is paid, SCC is paid. So you can use those online sites. They give you a better perspective and purview of the literature. There is no hindrance. Even if you read Wikipedia, Wikipedia is giving you a good stuff of literature. But the only issue is that there are certain things which are distorted. It is you do not rely exclusively on Wikipedia. You use all other things. Read the books also so that you have a knowledge of where things or facts have been distorted. It doesn't make a difference. Most institutions do not have Manupatra because it is paid and the cost is very heavy. And particularly the government institutions, they are not spending the money on Manupatra.
Yes, ma'am. Ma'am, the next question is how to review a law assignment.
How to review a law assignment. Okay. See, once you have written the assignment yourself or you are reviewing somebody's assignment. Again, the first thing is the first paragraph is the introduction. So what is the brief giving you? Introduction is a perspective of analyzing what I intend to carry through in the entire assignment. So it is in a brief of what I would be talking about. An introduction is also giving an overview of the subject on which you are talking about. So once you review it from the same perspective as to what the introduction, what he has specified, candidate has written down in the introduction, then what he is trying to say as the relevance of the subject, the definitions he has given, the legal aspect that he has focused upon, even if he has used the social perspective or the psychological perspective, since the subject demands that kind of thing, then whether that has been carried upon, whether he has conducted only an study within the country or it is an international aspect, then you can analyze those provisions also and how well they have been added and inducted it once you are reviewing it. Being a reviewer, you must be very well versed with the law and the subject or the topic which you are trying to review. Most of the reviewers do not know the subject and the topic, but since these days, for reviewing also, you are being paid. So it is like you review my paper, I will review your paper. So this kind of a culture has also been developed among the intelligentsia community. But being a reviewer, you should be well adversed with the subject so that you are able to find out what are the lacunas, where things have been missed out, where things have been added which are not required to be added at all. It is not that if we say that if I have written a paper, everything that is written was required to be written inside it. At times, that there are things which we feel that they have just been added in order to increase the number of pages. So it is not at all required, or it is not the demand as per the requirement. Then again, what has been derived from that research which has been conducted by writing that legal assignment, and what is the conclusion that the person has arrived at, and what suggestions have been laid down. Are they actually suggestions, or they have been there just for the sake of writing the suggestions? So as a reviewer, you owe a responsibility and a duty to understand the subject and to analyze it from a critical perspective so that you are addressing or guiding the person that these are the lacunas and they should not be repeated in the next paper. That is why we always give an opportunity. We send it back with the comments that the person can change it, moderate it accordingly, update it, and send the paper back.
Okay, ma'am. Ma'am, the next question, can your LLM dissertation topic become your PhD thesis?
Oh, yes, definitely. There is no reservation on it. If you are have taken up a topic, the only concern is that your topic has a perspective and a wider purview so that you can carry it in the PhD. Whether there is at times your topic is such that you only did a doctoral study because of the shortage of the time, but there is a purview and you can go in for an empirical study. then definitely you can go for it. You can even go for a comparative study. Not necessarily that comparison has to be made internationally. Comparison can be within the country also, between the states. It can be within the jurisdictions also. You can go north, south, east, west. Compare north with the east, or south with the east, or the west. So anything can be done. Only thing is that the topic of the thesis, or your dissertation or PhD thesis you intend to take up, that is having the scope and the purpose. The onus is on you. There is no reservation that it was in my LLM dissertation. I cannot write a PhD thesis on it. There is no such bar. You can 100% write it.
Okay, ma'am. Ma'am, the next question is, can I submit my legal assignment for publication? And if yes, what is the procedure?
See, you can write your assignment. You can forward it to. There are number of publishing groups which are publishing it. Number of journals are calling for it. You can send it to them. They will blind review once it is done. Then they send it to people in their panels they have selected, and they will review your paper. If any changes are required, they will specify the changes, market it, ask you to revert the paper back in 10 to 15 days. Once it is done, they will again reanalyze it, and then your paper goes through. They'll send you a message that your paper has been selected for publication. You can go for online publication, or you can go for offline publication. Number of publishing houses are there, number of journals are being published. So it is your choice. You send your papers. It will be number of people are writing books. There are book chapters. So even you there, you can send to them also. You look at law act papers. If, there are so many which are options which are available. They give keep on calling that someone is writing a paper on this book on this subject. If you are interested, you can send in your paper, and they're not charging you on that paper. So you can simply send your paper to them. If your paper is selected, then I think for getting a hard copy of it, you need to pay. If you take the soft copy, they are not even taking the payment.
Okay, ma'am. Ma'am, the last question. I
Right.
wrote an opinionated assignment and got less marks for it, but I feel I had done a good job. So,
Mm.
why is it important to be neutral and not okay to be opinionated?
See, it depends upon the perception of the person who is going to check your assignment. See, you cannot force anyone, and you cannot uh, be ensuring that what is my opinion should be the opinion of the other. Maybe the person was not able to digest your opinion, or he was not happy with the opinion you gave. He might have a more fundamentalist approach. So, the best part is, see, you may like to write an opinionated paper, you can write down, but before you conclude upon it, you should give the other side also. It is always good in the interest, in your interest, because you, since I cannot force my opinion on the other person, I should accept this fact also that he may like it, he may not like it. So it is always on a positive perspective that even if you give the negative side, your personalized opinion or ABCD's opinion, put the other face also on the front, so that the person is able to view both the sides. Then such things will not happen. There are few situations where we basically recommend, even being an educationist, that should not go for that thing, because that hampers your interest as a student.
Okay, ma'am. Ma'am, we are done with the queries. Can we wrap up?
Yeah, sure.
Okay, ma'am. Thank you so much for such a wonderful webinar. There was so much that we could learn from today's session. Thank you, ma'am.
Thank you so much for giving me the opportunity. Thank you.